When a law enforcement officer takes a child into custody, it's customary that the parents are contacted. In most cases, the juvenile is released to their parents with the understanding that they're supposed to report to court on a particular day at a specific time. But there are situations in which the officer is going to want to detain that child. There is not one particular way that this happens. We see differences across states and even within states, differences within or between jurisdictions. But generally speaking, there are two ways that a kid may be brought into contact with the detention facility. One way is where the police officer has the authority to simply bring the child to the detention facility. So the way that would happen is they would actually, if the offense were serious enough, they would go to the detention facility, and then the intake officer at the detention facility would decide whether the kid is going to stay there or be released to their parents. In some jurisdictions, that intake officer is also going to decide whether the case is processed formally or informally. The second way a police officer may bring a kid to a detention facility involves a process by which they have to seek authorization to actually do it. They may have to call an on-duty juvenile probation officer, or maybe even the intake officer they would call, and they would explain the circumstances surrounding the event as to why they think that child may need to be detained.
Once a police officer decides to take a child into custody and determines that that child needs to remain in custody, either to be safe or to ensure that they're going to appear at court, then the police officer has to decide whether that custody needs to be in a secure facility or in a non-secure facility. And oftentimes that's just based on the offense that the child's been taken into custody for. If it's a status offense, then the child's not eligible to be placed in secure detention. Once a child's taken into custody and approved by the courts, then a hearing has to be held within 48 hours to determine probable cause. And that has to be held by a judge or a judge's representative. If he finds that there is probable cause, then he can either maintain the child in custody of the courts, or he can release the child back to the parents or find another suitable foster placement.
If we're talking about a more serious offense, or in a runaway situation where the child is taken to detention or is placed at YOC in a cottage, some sort of placement other than just returned home, there's going to be a detention hearing, and that has to occur within 48 hours. And that basically is the probation officer or the prosecutor or the arresting officer who comes in and advises the court, here's what the facts are that resulted in my taking this kid into custody and placing him in detention. Then the judge has to make a call. Am I going to leave him in detention? Am I going to move him to a less restrictive placement? Am I going to return him home? Electronic house arrest? Whatever that decision might be, there's got to be a placement decision made first. Then we would get to the initial hearing.
Vizi online texts are a new kind of textbook, built with the help of great subject matter experts. These new learning resources have already helped thousands of students succeed. Our original content uses animations, simulations, video and graphics, self-assessments, exercises, and review materials to engage students in their study. Our approach is proven to improve learning outcomes, and that's why Vizi exists, to transform lives by making education more engaging.